So, what happens after the ink has dried? That's the question I want to start with. What happens after the ink has dried on the Singapore Convention? You've signed on the dotted line, you've ratified, what then? To be sure, the Singapore Convention is an absolutely crucial piece of the international mediation jigsaw puzzle and the international dispute resolution jigsaw puzzle. But to get the most out of this convention, it's important to have a robust, enabling mediation framework. And today I'm going to talk about what that means and what that might involve. You see, international mediation, and mediation for that matter, doesn't take place in a vacuum. It takes place in a regulatory and institutional framework. And the framework in which mediation operates can be a deliberately designed framework, or it can be one that just happens. But in any event, it's there. So the theme of this presentation is on how to design a robust, enabling framework, a regulatory and institutional framework for mediation in order to get the most out of the Singapore Convention on Mediation. So let me introduce 10 criteria for a robust, enabling framework for international mediation. The first criteria to think about is to what extent should cross-border mediation and domestic mediation be regulated in a congruent or harmonized manner. Now remember, we're looking at a situation where foreign lawyers and foreign users of dispute resolution will be coming to mediation, right, in your country. So having a regulatory system for mediation that is accessible, right, transparent, easy to understand, is an advantage. In complex disputes, sometimes there can be disputes about which elements of the dispute are domestic in nature and which elements of the dispute are international in nature. We see that in arbitration, for example. And to this end, it can be quite useful to regulate cross-border mediation and domestic mediation in a similar or harmonized way. In terms of the content of mediation law, we're not just talking about legislation. It's important to think about formal law, like legislation, and also, particularly in common law jurisdictions, case law that would be relevant or applicable. But it's also important to think about court rules, practice directions, institutional rules, institutional codes. It's important to think about sample clauses that lawyers would incorporate into dispute resolution clauses. All of these regulatory forms work together to effectively form the applicable mediation law. And research shows that around the world, a lot of the regulatory instruments for mediation are derived from soft law and supported by formal hard law such as legislation. So it's important to look at all of these regulatory forms. It's also important to think about what aspects of mediation can be regulated. Some people ask the question, well, should we regulate mediation or not? Because mediation is a flexible process. It's supposed to be an alternative to going to court. So do we really need to regulate it? Well, as I said previously, mediation does not take place in a vacuum. It does not take place in a legal vacuum. You cannot not regulate mediation. The question is, do you want to design your regulation for mediation, or do you just want to leave it to the general law? Right? If you design your regulatory framework for mediation, which is highly recommended, then it's useful to think about what aspects of mediation do we want to regulate and how. Here are 4 categories. You can think about, how do we get people to the mediation table? What laws or what mechanisms will trigger the use of mediation, and in particular cross-border mediation? They can be referrals from courts. They can be recognition and enforceability of mediation clauses and dispute resolution clauses which have mediation as an element. There are many examples of triggering mechanisms that are recognised by law for mediation. And again, the experience worldwide is that where there are strong incentives or triggering mechanisms to use mediation, that's where mediation has taken off. In those jurisdictions, you see a lot more mediation practice, domestic and cross-border. And some examples of those jurisdictions are Australia, the United States, for example. What about the mediation process itself? How is that regulated? That's usually left to soft law. That's the flexible piece. What happens at the mediation table? So that's where your institutional rules, your codes of conduct, right? That's where they come in. Then you also need to think about, who gets to mediate, particularly in the context of the Singapore Convention, right? There's a lot of attention now being paid to the standards applicable to mediators. Why? Because one of the grounds to refuse to enforce a cross-border mediated settlement agreement relates to the conduct of mediators, right? So how is the profession of mediators regulated? And again, usually a combination of institutional industry rules backed up by legislation seems to be the preferred way to do this nowadays. And then the next category is the rights and obligations of people involved in the mediation process, whether that be the mediator, lawyers, clients, anyone else in the mediation room, whether they're in a professional or personal capacity in that room. And here, legislation is often used. And we're talking about issues such as confidentiality. How is that regulated? Admissibility or non-admissibility of mediation evidence in subsequent arbitral or court proceedings. Here we're also talking about the enforceability of mediation clauses, dispute resolution clauses. We're talking about the enforceability and recognition of international mediated settlements. Now, that piece is covered by the Singapore Convention, but only that piece. We're also talking about how mediation may impact upon legal limitation periods for bringing an action in court. There are a range of rights and obligations associated with mediating that attach to the various players in the mediation process. And it's important to think about how they should be regulated. The Singapore Convention is one piece of this. It relates to the enforceability of mediated outcomes that fall within the Convention. But there are a range of other issues as well. So that's the essence of the first criteria: comprehensive, congruent law on cross-border mediation. The second criteria relates to mediation infrastructure and services. To be an attractive mediation venue, it's really important to have excellent high-quality infrastructure, facilities, mediation services, administrative services around the mediation offering. It's important also that there is state-of-the-art technology so that people can engage in mediation remotely. Many mediations at the moment in 2021 are conducted completely online, and many are also conducted in a type of hybrid form, with some people physically meeting and other people joining remotely. Right? Having good facilities and robust facilities that offer this is very important for the execution and the operation of cross-border mediation. It's also important for mediation institutions to have access to local and foreign mediators, particularly for cross-border mediation, because users like to choose their mediator. And this leads us into the third criterion. Many systems for accrediting mediators initially focused on local mediators. And it's important to revisit those as a jurisdiction when you're looking at moving into cross-border mediation to make sure there is appropriate access for well-qualified foreign mediators to participate in mediation in your jurisdiction. It's also important here to have feedback systems or complaint systems so that people know who they can talk to if they're unsure about what's gone on in a mediation, they want to change their mediator, etc. So far, Criterion 1 has focused on the law of cross-border mediation. And remember, we talked about law in terms of soft law and hard law. Criteria 2 and 3 have focused on more institutional aspects of mediation. And now we look at a number of criteria that are focusing on specific aspects of mediation law. So if you like going into a little bit more detail. So the next criterion, criterion number 4, deals with enforceability. And these are the enforceability of international mediated settlement agreements and the enforceability of mediation clauses or mediation agreements, agreements to enter into mediation. As we've discussed, the enforceability of international mediated settlements is covered by the Singapore Convention. Right? So once that is ratified, once there is enabling legislation, enabling laws within your jurisdiction, that is dealt with. It's important, though, to make sure that there is a sufficient regulatory framework around the enforceability of mediation clauses. In many common law jurisdictions, there is case law that makes clear that appropriately drafted mediation clauses will be enforced by courts, usually by issuing a stay on court or arbitral proceedings until that mediation clause is complied with. If there's a mediation agreement signed by the mediator, the lawyers and the parties as they enter into mediation, right, is that enforceable? Typically, yes, if it's appropriately drafted. But sometimes it's also helpful to recognize this in legislation, right? So it's important to look through these issues because the effectiveness of mediation depends a lot on the recognition and enforceability of clauses that effectively initiate mediation processes. Criterion 5 focuses on confidentiality in mediation. And again, we referred to this previously in the context of mediation law and making sure that domestic and cross-border mediation law is congruent. But it's important in the context of mediation to think about 3 different kinds of confidentiality. We talk about insider-outsider confidentiality, we talk about insider-insider confidentiality, and we talk about insider-court confidentiality. I'll just say a few words about each of these because all 3 of them need to be regulated and they may be regulated in different ways. Insider-outsider confidentiality deals with the notion that what happens in the mediation room stays in the mediation room. So everybody in the room has an obligation not to disclose to anybody outside the mediation, any third parties, what's gone on in the room. That's a general duty of confidentiality. Insider-insider confidentiality focuses on what happens in the private caucus sessions in mediation. Right? So if there's a private caucus session, a separate meeting within mediation, which is very common, how is the confidentiality of that regulated? And there are different ways to do that, so it's important to be clear on how that is regulated. And very often this is regulated by mediation rules or by the written agreement to mediate or mediation agreement. Right? Sometimes it might be included in legislation. The model law, the UNCITRAL's model law on international commercial mediation deals with these 3 kinds of confidentiality and actually also offers a provision regulating insider-outsider and insider-insider confidentiality. It also offers a provision regulating the 3rd kind, insider-court confidentiality. Now, I refer to this as confidentiality, but really insider-court confidentiality is about admissibility of evidence. Sometimes jurisdictions regulate this aspect of mediation with evidence law in the Evidence Act, for example. But other times it's also regulated by institutional rules, and also regulated in mediation agreements to enter into the mediation process. So it's important to think through how each of these elements of confidentiality will be regulated in your jurisdiction. Criterion 6 deals with the impact of mediation on litigation limitation periods. Mediation is often sold to people on the basis that you've got nothing to lose. You don't need to agree to anything you don't want to agree to. You can reserve your rights to go to court. And this works as long as the time period in which parties can file court proceedings does not expire during the mediation. And particularly in cross-border mediations, which may go on over a period of months, for example, this is possible. So it's important to know, in terms of the applicable law, how this is regulated. In civil law jurisdictions in particular, this is usually specifically regulated in legislation, some type of suspension or freezing of the litigation limitation period once mediation has begun. In common law jurisdictions, parties will often apply or may even agree to push back the time period for filing in order to engage in mediation beforehand. Criterion 7 deals with the court's attitude to and relationship with mediation. The success of the Singapore Convention depends in large part on the courts interpreting the provisions of the Convention. And that also in turn depends on courts and judges understanding what mediation is, understanding how mediation differs fundamentally from arbitration and differs fundamentally from litigation. Courts with well-developed mediation programs, for example, court-annexed mediation programs, referral systems to mediation, typically are well-versed with mediation and understand its nuances. So certainly having a court referral program to mediation is advantageous to developing the judiciary's capacity in relation to cross-border mediation. Criterion 8 deals with regulatory incentives for lawyers advising clients in relation to dispute resolution and mediation. Mediation involves a culture shift, a shift in dispute resolution culture for many lawyers. And this is true all over the world. So jurisdictions that have introduced incentives for lawyers or requirements for lawyers to advise their clients on mediation are typically jurisdictions that have enjoyed greater traction with mediation practice, both domestic and cross-border. These type of incentives can be found in legal professional rules, for example, duties to advise clients about mediation as an option. In some jurisdictions, there are even obligations on parties themselves to engage in mediation if it's reasonable to do so. And there's a corresponding obligation on the lawyer to advise clients. In this presentation, I'm talking about the mediation ecosystem. But of course, mediation exists within a broader ecosystem. It exists within the dispute resolution ecosystem. It exists in a dispute resolution ecosystem which also features arbitration and litigation. And again, our focus is on cross-border. So it's important not to forget that, and it's important to think about, how does the introduction of a regulatory framework for mediation, how does that impact on our arbitration framework? How does that impact on our litigation framework? And what interconnections are there? It's important to have linkages between each of these dispute resolution systems. For example, if parties go to arbitration, that they have an opportunity to move seamlessly into the mediation ecosystem if they wish, right? And that there are regulatory mechanisms that make it easy to do this and to move back to arbitration if they wish. Many arbitration laws already contain these type of provisions which allow parties to open a mediation window within an arbitration process. Right? That's just one example, though. Where courts have a court-annexed mediation program, that's an example of a link between litigation and mediation. So it's important that parties are able to move in an international dispute resolution ecosystem among these different processes and among these different institutions seamlessly. So parties could move from court to mediation and back to court, or over to arbitration, if they want to, in a seamless way. And jurisdictions and institutions which work together in this way offer an attractive venue and an attractive mediation-friendly jurisdiction in which parties can take their dispute. The final criterion is ongoing monitoring and review. Mediation's new. This is a developing dispute resolution practice. We're talking about a developing profession of mediators. We're talking about dispute resolution professionals who may offer arbitration services as well as mediation services. In some jurisdictions, judges will also mediate, right? So how do we manage and regulate this fast-moving space, right? It's important to put in very clear timelines and mechanisms to review the regulation that you've got in place. And this is easy to do where there is soft law. So to give you one example, in many jurisdictions, the credentialing of mediators is regulated by soft law, in particular institutional rules. And there are provisions to review this every 2 years or every 5 years, right? With a view to rethinking, do we need to change the rules about who gets to be a mediator and what they need to do to keep up their mediation or their mediator status? And is it time to move these rules from an institutional basis ultimately to a legislative basis? Should we move from accreditation to licensing, for example? We don't need to, and we shouldn't, I think, determine everything now with a view that this is the way mediation is going to be regulated in 10 or 20 or 30 years' time. This is an emerging and evolving profession, particularly in practice, particularly on the international scene. So it's useful to have, and now I'm linking back to criterion number 1, it's useful to have different forms of law, soft law and hard law, and it's important then to have review timelines and mechanisms in place so that the law around mediation can be adapted so that it is always best practice looking towards next practice. I began this presentation with the question, what happens after the ink is dried? What happens after the ink is dried on the Singapore Convention? What then? Will there suddenly be cross-border mediations non-stop? No. It's important to have a robust enabling framework dealing with regulatory and institutional elements. Accompanying this presentation is a paper that I've written called The Singapore Convention, What Happens After the Ink Has Dried. And it has been published in the American Review of International Arbitration. I encourage you to look at this article. It deals with the 10 criteria. It also uses Singapore as an example, just an illustration to show how one jurisdiction, Singapore, has dealt with each of these criteria. It's not a matter of having all of the criteria implemented immediately. I think it's really useful once you've signed on to the Singapore Convention and implemented enabling legislation or laws for that in your jurisdiction, to look at these criteria and think about, what criteria do we already have working for us? Where are there gaps? What can we work on next? It's an evolving piece, and I wish you the best of luck with it.